Hi, Dan Krause here. I want to talk about the Wisconsin statutory power of attorney. Like I said, my name is Dan Krause. I'm from Krause Estate Planning and Elder Law Center. We help elders and their loved ones preserve their life savings in the face of nursing home or other long-term care expenses. So powers of attorney are a very important part of every estate plan. Everyone who is an adult should have a financial power of attorney along with the healthcare power of attorney and many other documents. But I want to focus on the financial power of attorney. Now, the Wisconsin legislature several years ago created a statutory power of attorney that anybody can download and use. You download it, you initial in the boxes that you want, the powers that you want your person to have, the agent, we call them, the powers that you want your agent to have, and then you sign and have it notarized, and that is a perfectly valid Wisconsin power of attorney. In fact, it will work in any state as long as you properly fill it out in Wisconsin. It doesn't cost anything, and it works. The problem with it is that it doesn't cover every situation. Now, even though the power of attorney says, and there's a place that you can initial this, say, my agent can do anything that I could do. And that's wonderful. And in your mind, and in my mind, I mean, it's logical to think, well, that just means they could do anything that I could do. But they can't, unfortunately, because the power of attorney doesn't specifically allow for gifting. Now, why is that a problem? If I had a power of attorney agent, would I want them to give my stuff away? Well, no. I mean, doesn't make sense, except in the case of end-of-life planning. Now, a lot of times when we have a client who is facing the devastating cost of nursing care or assisted living care, they want to preserve for their family as much of their assets as they can. Part of the way to preserve the maximum amount of assets for your family is to gift some of your assets to your family or gift them to an irrevocable trust. Now, this would not be allowed in the general statutory power of attorney in the way that it is written and made out. That's one of the reasons why the power of attorney that we do for our clients is never a statutory power of attorney. We always use powers of attorney that we've developed. We use a lot of the forms that we pay for with our subscription to Wealth Counsel. And these powers of attorney are much more comprehensive, and they anticipate that people may need to give away assets towards the end of life. And they also may need to do some other things like creating a pooled trust or creating a subtrust under a pooled trust. Now, I won't go into what that is, but the statutory power of attorney also would not allow you to do that. So sometimes when people come in and they say, my loved one has this power of attorney and now we want to try to preserve their assets, and I say, great, let's see the power of attorney. If it's a statutory power of attorney, I get a little bit sad because I know that this is not going to allow them to do the things that they want to do. So, wrap up, statutory power of attorney is a great thing, but it's only limited to certain things. So if you really want a comprehensive power of attorney, you should talk to a professional about that. You could talk to us, especially if you're in Wisconsin and concerned about that. Our number is 608-268-5751, and our law firm is called Krause Estate Planning and Elder Law Center. I hope to hear from you soon. Thanks.